If I introduce myself, I'm Luke Clements. I'm the Cerebral Professor of Law and Social Justice at the School of Law at Leeds University. And that's where I'm going to be going by train later on today. I live on the Welsh borders. I've written a lot about social care over the years, been a solicitor for about 40 years. I've just stopped, thank God, being a solicitor. Spend my time in a research centre at Leeds, researching the issues about disabled children and their families, their rights to the law. So we're looking at these issues through a legal lens. And I'll be referring to some recent publications we've done, which have really exposed the fact that most local authority and government policies are not fit for purpose. They're, in fact, in my opinion, unlawful. So I'll go through that. Hopefully I'll explain it in not too legal jargon. And then if you have comments, if you could put them in the chat bar. I won't see the chat bar because I'll be presenting, so I'll just see the slides. But Laura's going to collate those, and then we'll try and pick themes when we have the discussion in about an hour's time, if that's okay. And if I cough and splutter, I think many of you will be coughing and spluttering. It's because I probably caught the same cold as you have, and apologies for that. So what I'll do is I'll put the slide up, and hopefully you can all see that first slide, which says disabled people 0 to 25 years assessment and care planning. So the idea is in today's session, I look at really quite a big span of law, assessment and care planning, not just for disabled children, but also for parent carers and young carers. And also I've been asked to look at transitions. On the next, and which is a huge subject, but we'll rake through it at speed. And that's why there probably will be less opportunity for discussion today. But on the 14th, we've got another session looking at the more in detail stuff about problems with direct payments and personal budgets and an absence of personal assistance. And hopefully we can have more sort of real-time discussion in that session. So I'll plow on through this. I've highlighted at the bottom my website, and that's because I get a lot of requests, which I normally can't deal with personally, but I try and put up commonly some useful resources there. So if you go to my website, that hyperlink, you'll see this is the page on resources. I've got a long list of challenging demands to repay direct payments, challenging care charges, reduction in care service, those sort of things. And each one of those will have a sheet explaining what I think the law is and how you can do that. On the left-hand side, you'll see I've got various things, a lecture series. A lot of these things I'm talking about today, I have sort of recorded YouTubes on them. If you go to publications, for instance, most of the publications that I do are on my website. And most of them you can download, not all of them. That book at the top, Clustered Injustices, it's a very short book. It's not expensive, but it isn't downloadable. But most of the other stuff is. So at the bottom of that slide, you'll see Disabled Children, a Legal Handbook. That's about 600 pages. That's got a lot of the wicked detail, much more detail than I'll talk about today on assessment, care planning, health, education, transitions. And you can freely download that. The Council for Disabled Children paid the publishers to make sure that's accessible. If you scroll down there, you'll see that. If you go down, for instance, there, if you click on Carers and Their Rights, which I do for Carers UK, 100 or so pages long, you can just download that and that comes up and you can read it all. So most of those publications there, Carers is free to download, Disabled Children, free download. The Problem Solving Toolkit, Laura and I were talking about local authorities blaming health and health blaming education and things like that. All these sort of problems that local authorities and health bodies throw up. There's a toolkit there that has a guide to dealing with commonly occurring problems. I think it's been downloaded or printed something over 50,000 times. And that's the recent book I've written. So what I've been asked to look at today are quite a long list. Outline the basics on social care law, the basics on assessing, what an eligibility decision looks like, a good one should look like, what sort of supports should be available, the rights of parent carers and young carers transitions. And because we're going up to age 25, from 18 onwards, effectively you jump ship, you jump from the Care Act, the Children Act rights to the Care Act rights, which is the adult. So we're going to look at what happens once you've gone through transition. You're then into the adult legislation. And although the system is similar, there's some different bits which we will look at towards the end. So kicking off, what I want to do is really say assessing need is very straightforward and it should be very simple, and there shouldn't be problems. There are, but what I'm going to do first of all is to just say basically what ought to happen. It's not complicated. It's really, assessing is what I think is called the what if question. What if the local authority doesn't provide me with help? What will happen? So I'm a parent with a disabled child, or I'm a disabled young adult or something. I need support. I ask the local authority's support. All they've got to really ask themselves is, what if we don't help Luke? What will happen? And normally they don't have to sort of go and say, well, is Luke a disabled person or not? Normally it's fairly obvious, blindingly obvious that a child is a disabled child. So that shouldn't be an issue. It is, and we'll look at that, but it shouldn't be an issue. Most of the time it's very obvious. You've got an education healthcare plan, the doctor's given you I don't know. Once it's clear that the child has an impairment, the young person has impairment, then they're a disabled child, then we've got to assess them. And the question then is, what will happen if we don't provide that person with support? And the greater the risk to the young person's health or their family's well-being, the greater the onus is on the local authority, the more dramatic the evidence is about the risks or what's happened or what's going to happen, the more difficult it is for a local authority to just sit on their hands and say no. And the more a court or an ombudsman would require them to give really powerful reasons why they aren't going to help. And an impact on, dramatic impact on a disabled person or their family's well-being isn't just physical, it's mental, social, emotional, their ability to work. So parent carers' ability to work and so on, or to stay in educational training. Those are all things that are well-being impacts that the legislation talks about. And once it's decided that there is going to be a need to put some support in there because there will be a serious impact if it's not, then the authority's got to basically just prepare a plan. And the plan is the wicked detail, the how, who, what, and when. Who's going to do this? When are they going to do that? Where it's going to be done and how often it's done. It's just the wicked detail written down in the specification. I'll come back to that later on in this talk this morning. But, what are the needs? How are we going to meet those needs? Who's going to be responsible for meeting these needs? And exactly what support service is going to be provided. It's not complicated. And that's how it should happen. But in practice, it doesn't happen. And that's largely because, well, for two reasons. One, local authorities are massively short of money, so they're trying to ration services, which they're not supposed to do, but they have to. And secondly, they are ruled in a managerial way, which is my new book on clustered disadvantage, injustice, in the sense that there's a sort of top-down, dictatorship really within many English authorities that give frontline staff very little room to be imaginative or discretionary. So looking at definitions, in a way, the key issue is in the Children Act, Section 17. And in a way, this is causing quite big problems. The Children Act isn't a great piece of legislation for disabled children. We're not calling for it to be reformed. That would cause just too much turmoil. But it does create a problem, because the Children Act says that local children's social services have a duty to provide, to promote the well-being of children in need. And then it defines children in need two ways. One is effectively children who are at risk of neglect or abuse if they don't get support. And that's about 90% of the people that local authorities assess children's services. And the other group are disabled children who are all classed as disabled, as children in need. And they're quite different groups, very different groups. And the problem that our research is showing is that local authorities deal with them in the same way. And that's unlawful. It's unlawful. It's unlawful. Sorry, somebody's unmuted.
Sorry, somebody's unmuted.
Is that all right? Yeah. So they're very different groups, and they should be dealt with completely differently, but local authorities are not doing that, or most of them are. They will have to do that fairly soon. I think the Department for Education will issue guidance to say you've got to treat these groups differently from the outset. Now, a disabled child, many of you will know, is defined in Section 17 of the Children Act as well. And it's defined very widely. It's a child is disabled if he is blind, deaf, dumb, or suffers from a mental disorder of any kind, or is substantially and permanently handicapped by reason of injury, illness, injury, or congenital formally. So the big issue is this phrase, a mental disorder of any kind. And as what you'll see is that mental disorder doesn't have to be substantial or permanent. That only applies to physical injuries or congenital deformities. So if you have a mental disorder of any kind, you are a disabled child, therefore you're a child in need, therefore you have a right to be assessed. And the Mental Health Act defines a mental disorder as any disorder or disability of the mind. So it would include high-functioning autism, attention deficit hyperactive disorder, PDA, pathological demand avoidance, and things like that. So disability is very widely defined, therefore it shouldn't be something that local authorities quibble about. Oh, I should say that you're all getting a copy of this handout. I should have said that at the beginning. They're going to be emailed to you, a PDF of this PowerPoint. So all disabled children who meet the definition have a mental disorder of any description or a physical or a mental impairment that is substantial and likely to be permanent are entitled to an assessment. That was said by the House of Lords many years ago. And the legislation also says that all people who care for disabled children are entitled to a parent carer needs assessment. And all young people, people under 18 who provide care, are entitled to carers' assessments. These are statutory rights, but all too often it's very difficult to get, in some parts of England anyway. I'm sure Hull is an area of perfection, but in some parts it's very difficult to get these assessments. And if a disabled child is assessed as needing support, then there is a duty to provide that under the Children Act and an act called the Chronically Sick and Disabled Persons Act. And we'll look at that a bit later. So that's sort of the theory about how it should work hunky-dorily. In practice, that doesn't happen. And there are various problems. And as I say, a lot of these problems, I think, occur for resource decisions, but also I think they occur out of complete ignorance of many local authorities with their legal responsibilities. Frontline staff in most local authorities, children's services authorities, are not trained in the law. And so they're not being deceitful when they behave in the way they do. They are simply ignorant of the law, and they're following a template, a script written often by a private company for the local authority that just doesn't reflect those legal responsibilities in our opinion, in my research team's opinion. So the first problem you come across is that some authorities say that if you've got certain impairments, you've got to jump over an extra hurdle. And that's particularly true for children who they say have got autism or attention deficit hyperactive disorders or something like that. What they say is having autism, having clear autistic spectrum symptoms or hyperactive symptoms is simply not enough. You've also got to have a diagnosis. Well, that's a medical diagnosis. Nothing in the legislation that says you need a diagnosis. Actually, the legislation is quite emphatic that it's not a medical model, it's a social model. And even if you, and as you know, for autism, a diagnosis might take several years to get. So until you've got that, the local authorities say, well, you're not a disabled child. And some of them say, you know, you've got to have a diagnosis and severe learning disabilities, or you've got to have autism and severe learning disabilities. Well, half of young people with autism don't have learning disabilities. Or they might say you've got to have a diagnosis of severe learning disabilities and challenging behavior. And again, or just challenging behavior. So it's autism plus one of these, or autism plus several of these. And many young people with autism don't have challenging behavior. So what we call these autism plus policies. Now they bear no real reflection on what the legislation, what Parliament says as a disabled child entitled to an assessment. So the local authorities are creating additional hurdles in addition to what Parliament has specified, and that's simply unlawful. And it's common. We've done some research on this, which is this report, and you can download this freely a couple of years back. And we are gradually chasing all local authorities that have those policies. Some of them say they've got those policies on their actual websites, and some of them don't, but they clearly operate those policies. Families will say, well, that's what we've been told. Even if you look at the website, it looks fine. So we're sort of chasing those down slowly. And I think any authority that continues to operate those is very likely to be at risk of being sued for discrimination, because that's discrimination against people with autism. And the Equality and Human Rights Commission have asked us to look at our recent work on challenging authorities that we know have these policies. So another problem that we've come across, and which really we're working on a lot at the moment, is that some authorities refuse to assess disabled children until they've tried short-term support, for example, early help or parenting classes. So you come and you ask a local authority for help, and they say, well, you've got to go through early help, or you've got to, you know, one of the things is we think you ought to go on a parenting class. Now, the legislation doesn't talk about early help. It doesn't exist in the law, or parenting classes. And those are totally inappropriate services for disabled children and their families, where there's no evidence of parental neglect or abuse. Where there's no evidence of parental neglect or abuse, they are utterly inappropriate. And yet the local authorities are suggesting that's the route you've got to go through and exhaust before there's any hope of going up into more meaningful services. And many authorities are saying, if you do have an assessment as a disabled child, the assessor will have to come to your home, maybe an unannounced visit or at short notice. Maybe the assessor will say, we want to look at the child's bedroom, we want to interview the child alone. Well, why is that? Why are you doing that if, you know, there's no evidence of neglect or abuse? What is that all about? And that's because you're being treated as if you were a neglectful parent, because we've got a one size fits all for everybody. And that we think is a severe violation of fundamental rights to privacy and respect for family home. You've got to have policies that treat people who are different differently. And if you don't, that is discrimination contrary to the Human Rights Act. And that's what we argue in a recent report called Institutionalizing Parent-Carer Blame. It's got a huge amount of publicity because it's resonated very strongly, I think, with very many families who feel that when they've asked for help, they've been treated as the problem rather than the family's difficulties in dealing with the way social services work. And if you looked at Hull, I mean, I'm not, I don't know anything about Hull, and it probably is a very good authority, but if you look at their protocol, for example, it says, it doesn't distinguish between children in need through neglect or abuse or children in need through their impairments. And it basically says that when there's an assessment or review, the social worker will have to have seen the child on their own, will have seen the child alone, and they will have visited the home and inspected the child's bedroom. And there's no explanation in that when it would be appropriate, when it would be inappropriate. That's just standard. And unfortunately, that's actually a policy that you can find in 87% of all English authorities, because that's just a standard off-the-shelf policy that Hull have basically bought into. And it's not fit for purpose, in my opinion, and it will need to be changed. And I don't think it's evil. I just think it's just lazy. And I think the way local authorities can sort these things out is through having meaningful conversations with parent-carer support groups such as yours. And I think this is going to have to happen. And local authorities are going to have to sit down and think very carefully about having a different care pathway for parents and disabled children. Because what we're seeing is, what should happen in practice is that if a disabled child comes to the notice of a local authority, if a family say to the local authority, we've got a child, it's got very significant impairments, it's suffering greatly at school, at home, in the community, we are not we're being quite severely handicapped by this because we can't go to work because we've not got support, we haven't got respite care, we've got other children, we've got all of these needs. The local authority should say, the first thing it should say when a parent approaches a local authority in that position is to say, well, this is the route for assessments of disabled children. And the first response should be empathetic. It must be really difficult caring for a disabled child. We really understand that you must, be very difficult to cope. Can't promise to give you support. We're very short of resources, but it needs to be a friendly, empathetic response rather than, well, we're going to have to make an unannounced visit to see you, and this is the checklist, and by the way, we could take your kid into care. But the response should be empathetic. There should be an assessment by not necessarily disabled children's team, but by social workers, social care assessors who have expertise in relation to disabled children. We're looking at training for assessors in basic disabled children's services, and many of them are not having that. The government has now agreed to mandate it, but at the moment there's no need that somebody assesses a disabled child that they've got any expertise in disabled children. They've got to have expertise in child protection, but not in disabled children with impairment-specific needs. And this is the good route. Once a disabled child has been assessed by somebody with expertise, the idea is that you would put in support that will not be short-term. Disability is not a short-term issue. It doesn't suddenly get better in most cases. These are lifelong conditions. So you are not talking about short-term interventions. You're talking about putting in support with annual reviews. And if on review it's seen that the care plan isn't working, then you would consider increasing the support because that's what is required. And then when the child gets to 18, you'll prepare a transition plan. So that's how it should plan, and then adult social service will take over. But what all too often happens is that disabled children are pushed down the route on the left, where they are assessed by a child in need, early help team, which is time limited, 6 weeks or whatever, intervention. And really the unwritten script is that it's to correct poor parenting. If that fails, then you are pushed up into Section 47, safeguarding issues. And if that fails, the child may well then end up being looked after. And that's why Children's Social Services in England overspent by £870 million the year before last, the last figures we've got, because so many children are being failed in this process. Rather than providing them with support early on, the local authority is then having massive costs later on when families simply can't cope. So treating disabled children in the same way as children who are suspected of neglect or abuse, pushing them down the generic assessment teams that focus on disabled children, that start with the presumption there's a parenting problem, is the issue. And as the big review that's going on, the McAllister review on children's services, Josh McAllister has said in his relatively recent interim statement that a consistent theme that he is finding, and he's appointed by the Department for Education, what the review heard is that families with children felt that they are navigating a system that's set up for child protection support. And the chief social worker for England, for children and families in England, has said much the same. As she says there, even where the sole reason for contact with children's services was because of social care needs of an autistic child, there was a tendency to use the social work assessment as an opportunity to judge parenting capacity through the child protection lens rather than through a lens of social care. This has long been a complaint of families caring for disabled children. So our legal analysis is really pushing at a good practice and failing that very senior people within the system who have the power to change things are also saying. So there must be hope. Now, you have this issue called eligibility. Not every disabled child will be entitled to support from a council. Obviously, councils have to manage their resources and meet those in most need. Their resources are inadequate, but the law says they've got to meet the needs of disabled children, although they are allowed to define what they think is an eligible need. And it's the legislation says that councils must have eligibility criteria that explain how, in general, they decide which disabled children will be supported. And these must be published. So we've looked at these. There's a duty to publish these. In our report in the Institutionalizing Parent Care of Blame report. And what we found is that these eligibility criteria don't decide whether a disabled child is eligible for the whole range of supports that are available to them under the Children Act, the Chronic Sick and Disabled Persons Act, a range of supports from personal assistant, night sitting services, day sitting services, community-based activities, adaptations, transport, a whole range of support services that Parliament has laid down should be available to disabled children. What the eligibility criteria tend to do is to say, not all disabled children can access these services. That you can only access these services if you've been assessed by the disabled children's team. Even if you're a disabled child, you still can't access these services that Parliament says you should be able to access. In our authority, you can only access these services if you've been assessed by our disabled children's team. And then they go and put huge restrictions on who can be assessed by the disabled children's team. And that's simply unlawful. A disabled child's need for support depend on their needs, not on which social service team assess them. I'm looking at your local offer, and I haven't really had time to look at this, but I think it would be good for you to reflect on these documents. The disabled children's team, to be ordered to be assessed by the disabled children's team in Hull, it seems to me that you've got to have some pretty serious conditions, way more serious than the legislation requires. Now, the legislation requires that you be assessed. It doesn't require that you be assessed by a disabled children's team. And I can see local authorities, I can see some wisdom in them saying many disabled children can be assessed by a team, a single point of contact team or something like that, who've got expertise in general impairments, but we will have a team that is dedicated to children with much more profound impairments. That's fine. What isn't fine is to say that unless you've been assessed by that disabled children's team, you can't access the range of services Parliament's given you. So in order to get assessed by the disabled children's team in Hull, you can see that you've got to have a diagnosis. Well, that's not in the law. And it's and you've got to have some pretty serious conditions, as you can see from that list. And then it goes on to that list is way more restrictive than the legislation. It then has an eligibility sort of spectrum, basically, from universal services, which in my opinion are not services at all. They're just basically, I don't know how local authorities can get away with calling, just telling you that what's available in the community is something that they're doing. But there you go. Then you get additional support. Then you get targeted early support. Well, early support is time limited, early help type support. It's called early help. And it's only if you get into the red zone that you get into the specialist support. The sort of support I'm talking about that's been identified by Parliament. If you look then at what you have to do, so on the left, you've got the orange targeted early help support, which can include disabled children with slow in reaching development milestones and so on. But these are time-limited early help supports. If you want to get into the full range of services reserved for disabled children, you've got to be in the specialist support team. It may be that I misread this, but that list there is for extreme impairments, but largely they're all about children who are at risk of neglect or abuse, as you can see. So we're getting, and I think the big problem when I was, looked very briefly at Hull's is it's not clear, it's ambiguous, but it's almost suggesting that unless you're in that extreme end, you're not going to have that specialist support, and that specialist support strikes me as being the support that many disabled children need. And it may not be substantial, but it might be, as I say, a night sitting service, a day sitting service, some personal assistance and so on, direct payments. So we get some cases here, I think I'm going to talk about. Yeah, so this is a recent ombudsman's case, a parent who was experiencing considerable difficulties caring for her son, who had genetic and development conditions, learning disabilities, pathological demand avoidance, and autism, and requested that they undertake a parent carer needs assessment. Now, the law says that anybody who is providing care, any parent caring for a child who is a disabled child under the Children Act, which is very widely defined, has a right to a parent carer needs assessment, a PCNA. But the local authority said, no, you can't have one because your child isn't the responsibility of the disabled children's team. And that was because the child wasn't severely, it wasn't disabled enough to be in the disabled children's team assessment process, even though the child was disabled enough for the Children Act. And of course, the Ombudsman had little difficulty in saying, well, that's simply unlawful. It doesn't matter who assesses the child. The child is a disabled child under the Children Act, therefore the parent has that right. An 2018 report concerned a child with significant mental health needs, in relation to which everybody accepted there was a need for respite care to prevent family breakdown. But this was refused by the authority because his impairment wasn't sufficiently severe to enable him to receive a service from the council's child health and disability team. And as the Ombudsman said, regardless of which team provided the care, the council assessed the need and it was under a duty to provide the respite care. So the Ombudsman considers that assessments must, regardless of whether this is done by a disabled children's team or a parenting or a single point of access team or early help team, the assessment must carefully and accurately set out the young person's needs. They must be sufficiently detailed so a proper decision can be made as to what services, if any, are required. If services are required, these must be specified, i.e. when action is to be taken, by whom, and for what purpose. If required, then it must explain why the assessed hours will meet the young person's needs. So if they're saying you need 10 hours respite care a week, the parents do, or the child needs support, then it's got to be explained why 10 hours is thought sufficient to meet the level of need. You can't have arbitrary, we only do 5 hours, we only do 8 hours. It's got to be personally tailored to meet that family's needs. And if there's no, if there's a decision there is no need for services, then this has got to be explained with reasons. The High Court has said local authorities must demonstrate that its assessment has been undertaken with the necessary rigor and width. This doesn't mean that local authorities are obliged to provide support, but it's required to make rational decisions as to what, if any, support is necessary and appropriate to meet the child's needs. And the Ombudsman said, it's incorrect to state that budget constraints are a legitimate reason for not meeting the identified support needs of a child. Each person within the council's area must be assessed on an individual basis and their needs met. Budget constraints must not dictate that level of support. All, I think, powerful quotes and things that you can use if you have these problems. And as I've already said, once it's been decided that you have these needs for support, you have to have a very detailed care plan with that wicked detail. And I'm not going to, you've got a slide. This is what generally should be on a care plan. And I often liken this to a sort of builder's plan, really. I mean, if you're going to make an alteration to your house and you want a wall down and a window enlarged, you don't say to the builder, well, just go and do it. You get somebody to draw up a detailed plan so that if something goes wrong, you can point to the plan and say, look, we said this is what you did, and you haven't done that. And that's what you need with a social care plan. You've got to say, well, you've accepted that these are needs. This is the plan, and you didn't stick to it. And yes, there was a crisis, but there's no plan B. There's no contingency arrangements, because of course, there's always going to be care assistants that become ill, care assistants that go on holiday, care assistants that get new jobs. So, and then you've got a piece of document, a written document you can hold the council to account for. Now, the range of support services that are potentially available for all disabled children, not just children who are provided with support by the disabled children's team or whatever, is a substantial one. It's laid down in this legislation, and in the disabled children's book that I referred to at the beginning, we go into these in detail. But this is the sort of range of things that you would expect to be on the menu when you're being assessed, all disabled children. And as I say, once there is an acceptance that a child is disabled for the purpose of the Children Act, then the parent must be offered a parent care and needs assessment. And we'll look at that after we have the break in a minute. Now, early help is not on that list. That list we've looked there doesn't mention early help. It's not mentioned in the legislation. I'm not saying early help is an inappropriate service. I'm just saying it's inappropriate service for disabled children and their families. Early help was mentioned in the Victoria Climbié inquiry by Lord Laming and by Eileen Munro, Professor Eileen Munro. She wrote a brilliant analysis of why child protection was failing in this country. And these two reports were all about abused, neglected children, and Lord Laming's was about a terrible death. And they recommended that local authorities be able to have sort of a very quick response, early help, where there was neglect or abuse identified, to see if this could be corrected before things got worse. Those reports are really silent on disabled children. That early help was never designed for disabled children. It's inappropriate, although it may well be appropriate for children at risk of neglect or abuse. It's designed to stop children becoming children in need. It can't apply to disabled children because they are already children in need. They've been defined in the Act as disabled children. They're not children that could slip into being in the category of neglect or abuse. And it's wholly inappropriate to think that councils can prevent disability or cure it by a short-term time-limited intervention. And parenting classes, which seems to be something that so many parents of disabled children are sent on. Again, there's nothing in the legislation that talks about that. It's wholly inappropriate, as it locates the problem within the family rather than society. The social model of disability says that people are largely disabled because of the inaccessibility of physical inaccessibility, attitudinal attitudes of people, administrative rules, and so on. It's the external world that's been created by able-bodied people that disables individuals, not the impairment that they experience. And it's basically, it seems to me, a completely inappropriate poor law concept that says really disability is just a family or private problem, not a social problem. So I'm coming to the end of this session, hope, and then we can have a break or open it for questions. Just talking about care reviews. So once you've got a care plan, there should be annual or initially for a short period. After 3 months, you have a review, and then annually afterwards. And the main purpose of reviews is to review the appropriateness of the package, not to reassess whether you're eligible. If the local authority decides that a review should be actually a reassessment, then they need to give evidence as to why they decided to reassess rather than just look at if the evidence was that the care plan was working well, then there should be no reassessment, because what's changed? And if the reassessment results in a reduction in services, then there needs to be very powerful evidence as to why this was. And it can't be budgetary. It's got to be to do with the needs of the individual or their families. Wow, I've raced through that. All right, Karen.
You want to carry on doing your next bit? Brilliant, yeah. Thank you.
Okay. So the next bit is just looking at assessing parent carers' needs. As I've already said, there's now a legal duty, and there has been for since 2015. So that's almost 7 years. Under the Children Act, Section 17ZD says there's a duty to assess a parent carer on the appearance of need. Appearance of need means that you don't have to ask if you're a parent carer. Once the local authority knows that you've got a disabled child, they should offer you a parent carer needs assessment. Our research shows that's not happening, but it should happen. And I think parent care needs assessments are crucial. A parent carer is defined as an adult who provides or intends to provide care for a disabled child for whom they have parental responsibility. So if you're caring for a disabled child and you don't have parental responsibility for that child, then there's another piece of law I'll explain that says that you should be assessed nevertheless. And it has to look at the well-being of the carer. So the assessment of the parent carer looks at the well-being of the carer, and well-being is defined in the Care Act, and we'll look at that in a minute. So the Care Act has a long list of things that amount to well-being. The Care Act is for adults, disabled adults or adult carers. And on that list, you'll see that well-being includes dignity, physical, mental health and emotional well-being, protection from abuse. But you can see E there is work, education, training. And I think that's a big issue. Because many carers have got to stay in work just to pay bills, or to for social and emotional reasons, or they want to go to college or stay in college or to do training. And when we're talking about personal relationships, we're also talking about looking after children, because many carers have have a disabled child, but also other children for whom they're caring. So that's what the Care Act says. And I think it's really important that you're supposed to have regard to the fact that the individual is best placed to judge their well-being. So I've just had a complaint that's been, I think the Ombudsman messed up terribly, but it concerned respite care. The child, the parent needed a break, and everybody accepted the parent needed a break. So the parent carer needs assessment says the parent carer needs a break. In order for the parent carer to have a break, the disabled child is then assessed for the additional support she or he will need, so the carer can have a break. And it was decided that there should be respite care. And there was a respite care centre to which the child was taken. But the child hated it and had to be dragged into the respite care centre, and the door locked so that the mother could leave. And that left her incredibly distressed. So she didn't get any respite at all. A, because she was driving the child there and back when she should be having a break. And B, she was just traumatized for the rest of the day. And the local authority said, oh, well, it's all right because the child settled down. Well, the mother is saying it's not all right because this isn't for the child, this is for me, and it's causing me trauma. And by the way, when you talk about my well-being, I'm best placed to judge my well-being, and I don't like that. I can't put up with that. So I'm not going to have that. I want direct payments, and I'll sort it out myself. So well-being, I think, is quite useful, and it's quite useful to sort of remind local authorities that it's the parent carer's well-being that has to be taken into account. And when you do that, they're best placed to judge what they think is best for them. So we got an Ombudsman report. I think this is a really powerful Ombudsman report, and it's worth spending a bit of time looking at. So this is a single mother with 2 children, and one of whom had significant disabilities and needed constant supervision. The council advised her that it expected parents to organise their work responsibilities around the needs of their children, and it wasn't their responsibility to provide direct payments solely to enable parent to work. Now, that is said so often, you wonder where that comes from, because that is simply untrue. As we've just seen, parent care needs assessment should look at keeping parents in work, education, training. They have just as much right to work as everybody else. If they can't work because of a child's impairment, then that's making them take the consequences of disability. That's privatizing disability to the family. And the social model says that, society's got to accept responsibility for these issues. So the local authority is just out of order, saying it's not our responsibility to provide direct payments solely to enable parents to work, because it can be. But they were saying, but we do give you respite care every other weekend. And so if you forego those weekend respite cares, then you could use it as a block in the summer to cover that problem. So she'd go without respite care during term times at the weekend, but in the summer that she could stay and work. So that would just is no break at all. It's no offer. They're just saying we'll be slightly flexible, but we won't give you any more. The Ombudsman said that was unlawful maladministration. The council had failed to understand the law. Yeah, exactly. The child's assessment and the carer's assessment feed into each other. The council knew that the son needed constant supervision. It knew that the mother was in full-time work and that the nature of her job meant she couldn't pursue flexible working. These were key factors, but neither the son's assessment nor the carer's assessment properly considered those issues. Government guidance clearly states authorities should not assume a carer is happy to continue in their caring role. There's no law that says you've got to provide care. Councils are required to consider whether a carer wishes to work. Nothing in the assessment suggested that the council had properly considered the impact on her if she did not receive the support during the school holidays. A good statement of the law, and that will come as quite a surprise, I think, to most local authorities that think that respite care is just something that you do for a few hours or maybe occasionally, and it's a sort of act of charity. It's not an act of charity, it's a legal duty. And it has to focus on the carer's well-being, and that includes their right to work, education, training, and leisure activities. And for non-parents, so people who are caring for a disabled child, but they're not their parents, there is a duty under the Carers Recognition of Services Act, 1995. So that's a sort of fail-safe if you don't have parental responsibility for that particular child. Okay, that's that. I'm going to move on, look at assessing young carers. So young carers have the same rights as parent carers to an assessment. Instead of being under Section 17ZD of the Children Act, it's under Section 17ZA. And there's a duty to assess a young carer on the appearance of need, again, like a parent. And it defines a young carer simply as somebody who's 18, under 18, who provides or intends to provide care for another person. So it's very wide. And there are very detailed assessment regulations. So young carers, there's a lot of law about that. There's a lot of duties on social services, but they don't seem to have grasped that particular nettle very well. And when they're doing the assessment, they should consider all of this range of stuff. I mean, and young carers, a third of all young carers are caring for a disabled sibling. 2/3 are caring for an adult with disabilities, often a mental health or substance misuse. But a lot of, a third of young carers are caring for a disabled sibling. And so when you've got a household with a child with significant impairments and brothers and sisters, and also parents who are, having to juggle their caring responsibilities between the disabled child and their other children, then you're going to need a whole family assessment that feeds into each other, but it would need to be also individualized so that we can see the parent carers assessment, because that will focus on the parents' right to work, education, training, have personal relationships outside the family, as well as meeting the disabled children's needs and the other children's needs. I've been asked to look at transitions. So this is really a legal transition. It's from a disabled child getting support from the children's team to a disabled child getting support from the adult team. But when a child is transitioning from basically the Children Act to the Care Act, there are other people that will be transitioning as well. So the parent carer who is caring for a disabled child will have their rights under Section 17 ZD of the Children Act. But once the child becomes 18, the parent carer will actually have their rights under the Care Act, Section 10. So the parent will be moving from the responsibility of the children's team to the responsibility of the adult team. And also, if there's any young carers involved, they will be basically moving with the child from the Children Act scheme. If there's a young carer becoming 18, the young carer under 18 will be getting their assessment under the Children Act. But once the young carer becomes 18, they'll be getting their assessment under the Care Act care proceedings. So you've actually got three groups of people transitioning, although we tend to focus just on the disabled child. And what used to happen was problematical legally. I mean, transitions are normally not, well, in my experience, transitions are often not handled at all well. And I think that's because of the way it's handled. But there was also a legal problem about it, which has now been resolved. I think they're still handled badly, even though the law's been sorted out. Under the old law, you had really two key milestones. When the child was 14, if they've got an education healthcare plan, then clearly you start the transitional process, or you ought to start this transitional process. And that should carry on. If they haven't got an education healthcare plan, there's also another piece of law, the Disabled Person Services Consultation Representation Act, that says it should happen about that time. So in theory, the children's services should be preparing this transitional arrangement when the child gets to about 14. But under the old law, really nothing happened until midnight before their 18th birthday. And then on that day, they would be under the Children Act. The adult team didn't have no duty to assess the disabled child until they were 18. And so they were really on a cliff edge, that they got, might be getting a good package from the Children's Services Authority Department until they're 18. But when they became 18, they suddenly had to be supported by the adult team, who were under no legal duty to have assessed them. So you would then have that sort of period when there were assessments, and so there would have been a real sort of service provision problem then when they flipped into adult social services. Now that's gone, and so legally that doesn't happen anymore. You've now got two more milestones. You've got a 16 one, and what I say a CM, which is convenient moment milestone. So it's flexible. So you still got this issue of you should start planning at 14 under the Education Healthcare process and the Disabled Persons Act 1986. What the Care Act now says, so it's the Adult Act says, is that once a disabled child is approaching adulthood, there should be an assessment, and we'll look at when that assessment should happen in a minute. But it's generally thought to be about 16 or 17. I mean, it must be 17, but it could be 16. They are assessed, and it's the adult team that has a duty to assess the disabled child at the appropriate time, 16, 17. And the adult team has got to say, when you become 18, these are the services, this is the care plan that we will provide, so that everybody knows what's happened as the child is coming over the horizon. When the child gets to 18, then they will continue to get support from the children's team. They will continue to get support from under the Children Act until a convenient moment happens in their review when you can then switch to the adult team. But it isn't a cliff edge anymore. So it's assumed that most disabled children, once they become adults, will continue to get exactly the same package from the children's team until there's a convenient moment to hand the baton over, basically, to adult team. So in legal terms, there is no problem. In practical terms, I just see as many dreadful transition arrangements today as I did 5 years ago. And there's a general formula that goes like this. Where it appears to a local authority that it's likely that a disabled child, a parent carer, a young carer will have care and support needs after transition, and it will be significant benefit to be assessed, they must assess. That just says, you know, if the child lacks capacity, they've got to do a best interest assessment. And if they don't do that, they've got to give reasons for refusing to assess. And the question is that they've got to assess. The question is, when do they have to assess? So if a disabled child is getting support or is known to the disabled children team, then the guidance quite clearly says they are likely to have support needs after transition. So that's not a problem. The question is, when is the key moment? When will it be of significant benefit to do it? Would it be 16 or 17? And the guidance under the Care Act has an interesting example, and you can download the Care Act statutory guidance. Just Google Care Act statutory guidance, and then just insert and just search against the word Isabel. There's an example called Isabel's story. And this is a situation of somebody who's 16 and she's in residential special school. And the parents say that she's going to, on transition, she's going to stay in college, and that they want a transitional plan started at the age of 16. And the local authority says, well, it's not necessary because she'll carry on in the special school until she's 19, blah, blah, blah. And the parents say, yeah, but when she gets to 18, she's not coming home. She's going to need to go into supported living. You know, that's the moment we are going to put down a marker and say that we want her to be living close to us. We want to be very involved in us, but we want her to transit into supported living at that stage. And the statutory guidance says that in that situation, given that it would take quite a long time to find appropriate supported living in that area, it was appropriate to start that planning process at 16, not to leave it until her 17th birthday. And the Children Act 1989 says that children's services will have to decide the best, children's services and adult social services will have to decide the best time to transfer, when is the best transfer to respect the transfer their respective responsibilities. And the SEN code says, under no circumstances should young people find themselves suddenly without support and care as they make the transition to adult services. Very few moves which should take place on the 18th birthday. and children's services just can carry on providing support services once a child's become 18, which didn't used to be the case. Families must not be faced with a gap in provision of support on the 18th birthday. If by that date the necessary support is not in place, then the existing services must be continued until the relevant steps have been taken. So that's sort of wrapping up the bit under the Children Act and the transition. Legally, a lot of this is very clear. In practice, it's just not really happening. I just wanted to quickly then rake through what happens when a disabled child becomes an adult, because then they have to be assessed not under the Children Act, but the Care Act. And then I'm pretty well done and we can have some more discussion. Under the Care Act, an adult in need is somebody 18 or over, and they have a physical or mental impairment or illness that requires need. There's a much more rigorous process about assessing adults, much more detail. So an adult in need is much more widely defined than a child. Well, an adult in need, as we said, a disabled child is defined as somebody who has a mental disorder of any description or is permanently or substantially handicapped. We wouldn't, that's old-fashioned language we wouldn't use anymore. And the Care Act, which is much more recent, just says an adult need is somebody who has a physical, well, the regulations say an adult in need is someone with a physical or mental impairment or illness. Very wide definition. And a carer is just an adult who provides or intends to provide care for someone, but isn't basically paid to do that. There's a duty to assess on the appearance of need. Individuals don't have to ask to be assessed. Local authorities, if they're aware of them, should assess them. And Section 9 says that that's the duty to assess adults in need. And Section 10 says this is the duty to assess carers in need, adult carers. And again, there's a duty to promote the well-being both of carers and of disabled adults. And as I've already told you, and we've seen, well-being is very widely defined. The Act itself, it says explicitly that local authorities can't assume that carers are willing and able to provide or continue to provide care. In fact, there hasn't been a duty on family members to provide care in the UK since 5th of July 1948, when the National Assistance Act came into force. So that's spelled out in the legislation. This very detailed eligibility criteria for adults. It's laid down in regulations, and that's a problem with Children Act. Is there is no detailed regulations in England concerning the duty to assess disabled children, but there is in relation to adults in need. And effectively, they have to jump 3 hurdles in order to be assessed as need. So the adult, in order to be assessed as eligible, have to jump 3 hurdles, and a carer, in order to be eligible, have to jump 3 hurdles. The eligibility criteria for adults in need are slightly different to the eligibility criteria for carers in needs. And the three hurdles for an adult, a disabled person, is that their needs have got to arise out of their physical or mental impairment, so that the need is a consequence of their impairment. That as a result of those needs, there's 2 or more outcomes on a list of 10 that they can't do. And that if they don't have help, that would cause them significant impact on their well-being. The carers' eligibility are just the same, except A is different in the sense that it says that the need arises not because of a physical or mental impairment, the need arises because of a caring responsibility. And B is different because for an adult in need, it says that the need's got to be such that the adult can't do 2 things on a list of 10 activities of daily living effectively. Whereas with a carer, there's a list of 9 things. And if they can't do any of those, just 1, they will be eligible. But in this case, we're looking at a disabled child who's become an adult. They're being assessed under the adult legislation now because they're 18. They've got to have a need arising from an impairment. Because of that, there's got to be 2 things on a list of activities of daily living they can't do, and that's going to have a significant impact on them. The list is this one here. So it's maintaining nutrition, managing nutrition, hygiene, toileting, and so on. And each of those A, B, C, D, E, F headline there's quite a lot of additional detail put in to explain what is meant. So managing and maintaining nutrition isn't simply not dying of starvation or dehydration, but it's also enabling people to prepare food. So that means they've got to be how to actually do it themselves. It's not a question of just giving them pre-cooked frozen meals. They've got to have the ability to prepare food themselves if they want to, and that would include shopping and using fresh food and so on. So yeah, wow, I've gone through. We've now got plenty of time for discussion.